Welcome to the Payments Experts Podcast, a podcast of global legal law firm, ISOs, fintech, PayFacs, agents, merchants, processors, acquiring banks, and card brands. If these terms mean something to you, this podcast is for you. If these terms aren't so familiar, this podcast is even more for you. We hope you enjoy this episode of PEP, the Payments Experts Podcast. Welcome to this episode of the Payments Experts Podcast, a podcast of global legal law firm. Today, we are very excited to have in studio with us Senior Associate Attorney Jarvis Lagman, as well as Associate Attorney Bill Petti. Gentlemen, I believe that the topic today is SEC, subpoenas, regulation. Please jump right in.
Thanks, Jeremy.
Thanks, Jeremy.
Just to give a quick outline of what exactly are federal securities laws and what they govern, right? Essentially, federal securities laws are intended to enable potential investors to have access to sufficient information to make an informed investment decision, right? So a lot of federal securities laws relates to, disclosures, right? So if you ever see things like a Form 10K, a Form 10Q, a Form 8K. These are periodic reports issued by public companies, detailing information about the business, financial statements, information about the corporate management of the company. They're all designed for a customer or a potential investor to be able to review this information and understand whether or not an investment in that company is a good or bad decision for them, right? And a lot of how federal securities law interfaces with the payments industry is that a lot of payments industry entities are public companies, right? So to the extent that they're public companies, they are required to make these disclosures, and any representations that they make in the disclosures are essentially going to be governed by securities law. So when we think about how the payments industry actually works, right? So a lot of it will involve sales agents going to different merchants and making representations as to what kind of services a particular company will offer, right? To the extent that a sales agent may make a misrepresentation to a merchant for the purpose of essentially increasing earnings, which has an effect of increasing a company's stock price. There may be an administrative action, concerning stock fraud or something like that, if it is indeed found that agents were making misrepresentations with the ultimate purpose of influencing a company's stock price. So I think a pertinent question is if you are a payments company and you essentially receive an administrative notice from the SEC, what should you do?
Well, I think the first question, and first I want to start off by saying thank you, Jarvis, for having me today. It's great to get your expertise on this area. I guess the first question you, as a individual in the payments industry, is first and foremost, what even is the SEC? Would you be able to explain that to our audience?
Sure. The SEC is an administrative body, essentially under the executive branch of the U.S. Federal government, that administers the federal securities laws, right? So, they promulgate different rules and regulations that take the Securities Act, Exchange Act, Investment Company Act, Investment Advisors Act, and helps flush out some of the standards in those laws to develop a body of regulations that are binding upon anybody who could essentially affect the purchase or sale of a security or the operation of a securities market, right? So, so to the extent that anyone or any entity is in violation of securities laws, the Securities and Exchange Commission will essentially govern that behavior and either, enforce administrative action or, in a lot of different cases provide guidance. But, they're essentially the governmental entity that, serves as the interface with government to basically interpret federal securities laws and, and govern how they're enforced. Which leads to, I guess, the question of when you actually go and, you're operating, buying and selling securities, and I think where a lot of this stuff interfaces with payments is that, there are just situations where you may not necessarily intend for your behavior to have the securities laws apply to your behavior, but because the securities laws are pretty broad, they will impact how you need to organize your activities, right? So I think in terms of being able to organize your business in a way that's compliant, you have to think about, A, to what extent am I doing anything that could constitute misrepresentation? And B, to what extent are the things I am doing involve the purchase and sale of securities? I'll give you a more pertinent example of this, right? So if you think about what's going on with cryptocurrency, right? So now the SEC, I don't know if you've seen all the stuff with Coinbase and Binance, right? The SEC has really cracked down and labeled cryptocurrency instruments as securities and as being, required to register under the federal securities laws, in connection with the purchase and sale to investors, in which, they typically have not done in the past, right? So now we kind of see how, the slow-moving engine of the SEC has finally wrapped their heads around how they actually want to approach some of these issues, right? So if you actually, so if you take that idea of like, oh, something that you may not necessarily think would be a security actually is a security, this influences, even the payments industry, right? So to the extent that, a payment card could be used, or let's say you're a payments company and you create a payment system that enables people to purchase cryptocurrency using a Visa, MasterCard payment method, right? All of a sudden now it's not just a typical purchase and sale of a good. Now it's something that you need to comply with federal securities laws, and there are just certain aspects of it where there might be a know your customer obligation, because if you're doing something where you could be deemed to be a broker in the purchase, or broker dealer in the purchase and sale of securities, now all of a sudden you have all these obligations that you would not necessarily have if not for the securities laws. So just in terms of how payments kind of interfaces with securities, because payments are evolving, right? Now we see how how we actually need to structure payments becomes more complicated, because some of these methods of running payments are looking more and more like securities, right? And I'm defaulting back to crypto, because it is one of those things, right, where if you think about the evolution of fintech, to what extent are these digital transfers of money, at what point can they be considered securities? So I mean, and I think we had a recent case, right, where we had a sales agent who was an agent on behalf of a public company, right? And they're going out and basically representing to merchants a solution that the company offers that was disclosed in their public filings that allegedly they did not actually offer, right? So that's another way that the securities laws can interface with payments, because to the extent you're a public company and you're representing things to customers, merchants, about goods and services that you report in your periodic filings that you actually don't offer for whatever reason, the SEC could come after you. So can you elaborate more on that process, Bill?
What aspect would you?
Well, I was speaking specifically in terms of, a situation where an agent on behalf of a company that is public but also offers payment solutions, but adverts are essentially solicits merchants, in connection with goods and services that they don't actually offer, right? And then all of a sudden now the SEC gets involved, and there is, there's an administrative order and subpoenas, and you're asked to go before the SEC and testify. How is that process like? What's the procedure? What should you do if you're ever in that situation?
Yeah, so the SEC, they have broad authority to regulate anything related to the potential violations of federal securities laws. With that comes the administrative subpoena power, which most people don't really understand. Most attorneys don't understand it. It's a very complex body of law specific to federal administrative law. So in a situation like that, the SEC might come in and investigate potential misrepresentations, and in doing that, issue subpoenas to non-parties. Upon receiving a subpoena, you might be wondering, why am I being roped into this? And in most cases, or some cases, you might not even be the subject of the investigation. So it's important to hire an attorney to review the subpoena and determine a date of compliance and the scope of the records that the SEC is requesting from you, and comply with what the commission wants you to do.
How is this process different than a typical civil litigation proceeding?
Yeah, so it differs a lot actually. It's almost like less formal. It's most litigators will deal with the federal rules of civil procedure, which they almost in a way don't apply to administrative proceedings. An administrative law judge can apply the federal rules of civil procedure and the federal rules of evidence, but they're not bound to. So it is it requires you to think on the fly when handling these types of cases.
So do you think that the discretionary power that these regulatory agencies have, as compared to maybe a more formalized judicial setting, do you think that's better for the process, or do you think it's worse? Do you think that when you actually go through a proceeding that you're protected by due process to the same extent?
I think that remains to be seen, and it also depends on the regulator. I guess in the context of just the SEC, I think in terms, well, you absolutely have certain rights to due process, or you have the rights to due process, and the government can't overstep their regulatory authority. With that being said, if you have an adverse decision made against you, a ruling by an ALJ, administrative law judge, or the commission itself, you have the right to appeal that to either a district court. It depends on the circumstance. In most cases, it'll actually go to an appellate court. In our circuit's the Ninth Circuit, so you would appeal that decision to the Ninth Circuit. But once you're in court, the judges, they give great deference to the administrative agency. So you'd be hard pressed to fight an SEC decision, but particularly as we've seen lately with certain decisions made by the SEC, there's some room to fight their decisions.
So do you think the process works better this way, or do you think that a lot of these actions, right? Because I guess part of what I'm thinking is what's nice about the SEC and the regulatory body adjudicating some of these issues is because they have sophistication and specialized knowledge that maybe a typical district court judge may not have. Having said that, do you think that, how would you balance the pros and cons of the different ways to approach securities regulation, right? Because on the one hand, you have an additional layer, and and it sounds like from what you described, even though you do have this right to appeal a decision because of principles of comity and the deference that judges will show towards the SEC, that obviously puts a finger on the scale in a way that essentially renders any hope of actually overturning any of these decisions a relatively illusory point, right? So, and especially given, how there's been a lot, I feel like not to, bring in politics here, right? But, on the one hand, there are political positions that really favor a stronger administrative state. And then there are other positions that say, well, these administrative bodies actually create a chilling effect on, on the way we're able to actually, engage in commercial activity. So, do you think that the current system strikes the appropriate balance, or do you think that there are things that we could do to essentially either streamline the process or, make some changes, to make the process work better? What are your thoughts on that?
I absolutely think that it's a good process that's beneficial for society. Having said that, I do believe that people should consult with attorneys or specialists and determine their rights and obligations under these statutes and the agreements they enter into. I believe that people should, understanding their rights, push back a little bit on these agencies, the SEC, the FTC. Just there's always going to be a power struggle, like balance and imbalance. So I think it's good that it's a good system, but there's definitely flaws that need to be worked out through the administrative process.
So are you saying that, that people are actually more empowered than they think they are, given the structure of the system, and the fact that you'd get some kind of notice from one of these enforcement agencies doesn't necessarily mean that you need to bow down to them, and then with adequate representation you can kind of fight, and I guess, like I said, I'm thinking about Coinbase, where it's like, okay, the SEC issued a ruling, and then now all of a sudden they're fighting it in court, and now we're really having this struggle over what the, not just necessarily how a particular provision in securities law would be applied in any specific case, but just really to what extent can the SEC, arbitrary, I don't want to say arbitrarily, but essentially rule make in a way and define the parameters of the conversation. Because I think a lot of these regulatory actions, it's not just that there's a law and then they're applying it. They're really shaping the landscape for how future businesses and how we're all going to kind of conduct or what kind of activities we can and cannot do moving forward in a way that I think is different than maybe a typical case where a lot of it's very case specific. And in my mind, that's some of the difference between maybe a traditional judicial proceeding and a regulatory proceeding, whereas a judicial proceeding, is very, very idiosyncratic to the facts and circumstances of the case, whereas administrative proceeding, kind of I feel like has a broader reach, just because now it's going to influence how an administrative body is actually going to enforce the law. I mean, would you agree with that statement?
Yeah, I do, and I feel like the with the rulemaking, there's to your point about receiving a subpoena, it works a lot differently than in the judicial system. There's different mechanisms that an administrative agency needs to follow certain procedures, and when issuing a subpoena, it requires a formal order, and it's important to request that type of information when upon receiving the subpoena, to request from the attorney who issued the subpoena the formal order. If they don't have the formal order, you could fight the subpoena and potentially quash it in the district court. So
do you think that there is more of a procedural chess match involved in a traditional judicial proceeding than in a regulatory proceeding? There's a little more leeway to assert your rights in a judicial proceeding because you can challenge, for instance, the validity of a subpoena, and there are just different ways to kind of attack actions that necessarily wouldn't be to your your best interests. but under an administrative action, you're a little bit more, there's room to fight, but but the scope at which you could fight is diminished as compared to a judicial proceeding.
Yeah. It's in an administrative proceeding. Sorry, can't talk today. In administrative proceeding, it's definitely a little bit more, or a lot more actually, a lot more procedural in terms of like the your what you have at your disposal to challenge either the ruling or the subpoena or whatever it may be. That's in contrast to in the district court where you have more of a factual basis for fighting. You're more fighting on the facts, but in when you're challenging the administrative ruling, it's you got to know procedure, and you have to know the Administrative Procedure Act.
So, so what do you think best practices would be? So let's say you're running a company, you're a sales agent or someone operating in the payments industry. What are some of the things you need to know and to govern your behavior both ethically and legally in order to kind of avoid all of this?
In what sense?
Well, for instance, so what are the kinds of things that you need to be aware of so you don't get in trouble with any of these bodies, right? So like for instance, just, and I'm thinking specifically in the context of just representations and things like that. Like, what are the kinds of causes of action that could be brought against you, and how can people mitigate the risk of being liable for that?
Yeah. So first off, especially if you're a public company, make sure in all your public filings to have a forward-looking statement when you're making representations to the public, especially when you're making representations for the purpose of receiving funds to run your business.
Wait, so what's a forward-looking statement?
Forward-looking statement is a conditional statement that is made to
It's more of a projection or forecasting. So
Yeah.
so is it something like language like not saying that you have done something, but you will or you intend to, like that kind of qualifying language? Is that what you would say constitutes a forward-looking statement?
yeah it's
And that there's a safe harbor for it in terms of misrepresentations in the event that people are relying on it. So I guess to the extent that people are making forward-looking statements, would you say that when people are putting together sales guides and things like that, that they need to essentially coach their sales agents to couch some of the representations that they make to their customers in this language?
Yeah. Yeah, you need to have like your compliance procedures on point, and you need to make sure that the language is not definite. You're not over-promising, and that it is every statement you make that might potentially be found to be misleading needs to be qualified with a forward-looking statement.
Where, gentlemen, would someone who's listening to this right now, who is potentially in need of services that your guys are pointing to related to having an attorney review these documents, et cetera, who is the ideal client in this situation?
Well, I think a lot of businesses who interface with the customer, right? Everybody could use a little bit of coaching in terms of, because I think what ends up happening with, let's say you're an entrepreneur, you start a business, you're very focused on your operations, you really focus on sales, but there are nuances to how you need to conduct, your sales activity in a way that, insulates you from some of these laws, right? So I think, I think that's, maybe one of the things about securities law is that it does impact everybody. And, so for instance, if obviously if you're a public company, but even if you're a private company and you take on private investment, right, to the extent that you are either making misrepresentations to private investors, right? So if you're a business and and you have someone, an angel investor who invests like $100,000, and you tell them, okay, give me 100 grand and I'm going to give you 25% of my company. And we're doing X, Y, and Z, but then you're actually not doing X, Y, and Z. It doesn't matter if you're a public company. You're in violation of securities law because you sold somebody securities in your company on the basis of misrepresentation, right? So anybody who's running a business and they're raising money or selling, selling equity positions in their company, right? They all need to be cognizant of the securities laws and the manner in which they represent, the value of the business, the structure of the business, the operations of the business, the assets of the business, everything having to do with the business that you're representing to other people. And then they're potentially, investing some portion of their money into it, regardless of whether or not you're a public or a private company, the securities laws apply to you, right? And even just something even more basic, right? And I think a lot of times, because there are specific exemptions from, certain securities laws, uh, whenever you're selling to people, even like friends or family, if you're selling to more than a handful of people, this could essentially constitute an offering where you need to file something known as a Form D, right? So if you're offering securities to, such like more than like 8 people, right? You need to file a Form D, and there may be notice requirement. If you're selling securities in California, California securities laws require notice and a payment of a fee. In my experience, I know a lot of companies, they'll form an LLC, they'll sell units to different investors, but they'll never actually comply with, the specific requirements of California and federal securities law because they don't think about it, right? And a lot of times they're not required to think about it because, for instance, when I was doing IPOs, a lot of my job, prior to doing the IPO wasn't just negotiating, the underwriting agreement and navigating the SEC approval process and interfacing with the exchanges. It was also cleaning up the company so it's ready for public consumption, right? The idea of going public is you're taking a peek under the kimono. My job, right, is to make sure that when you actually peek under the kimono, it looks pretty good. So in my experience, a lot of times, without, and this is what's actually good about securities law is that because there's a transparency, it forces everybody to adopt best practices in the way that they manage their records, the way that they do their financial reporting, the way they do their accounting, right? But without that pressure, people kind of run their business very haphazardly. Maybe they'll hire a CPA to run their books and have their and file their taxes. But the actual record keeping and, like for instance, even just the idea of forming an LLC, you need to have an operating agreement. You know how many LLCs, we've represented that, they file the paperwork, which is like a one-page paperwork. They get the LLC, they get the federal tax ID number, but they haven't built out the operating agreement. And then all of a sudden now there's a dispute between the members, right? And then they didn't fulfill all the requirements of what this organizational structure needs for it to operate properly. And then that's when they bring in the litigators because now they're suing over a dispute over membership interests or profit distributions but they didn't actually comply with all the requirements needed to form these entities properly. So I think a lot of what securities law does is it actually does establish a baseline for this is the standard you need to uphold to be able to own and operate a business. Right, in the absence of that, you actually find that the standards at which people operate their businesses isn't to that standard.
That seems to provide, like you mentioned, Jarvis, a good public utility as well, kind of keeping people open and everyone being straight with one another. I'm curious if you gentlemen are able to discuss it all, obviously not particular details, but is there any case or a particular type of client that Global has represented or is representing that presents an interesting issue related to regulatory defense that you guys are able to discuss?
Well, in terms, right. So I'm more of the transactional guy than the litigator. So so I think some of that question is directed towards Bill, but I think just in terms of what Global Legal Law Firm can do in terms of securities law, right? So there's obviously the you run into a problem with an administrative agency. We have more than a dozen attorneys are eager to take on your case and be a zealous advocate to protect your rights. And I think that's without question. That is what we do. But I think from the transactional side, what we could also do is we could provide very, very sophisticated knowledge of the payments industry, but also implement that in a way that takes advantage of the fundraising capabilities permitted under the securities law, and essentially structure deals and structure a company in a way that maximizes ROI in a way that's fully compliant.
Yeah, and there have been instances in the pre-litigation aspect where individuals who have either whether it be their employer or their ongoing business relationships end up getting roped into an SEC investigation. You do have rights in that situation because you're going to have it dealing with an SEC subpoena. It's not free. It costs money. There's all types of costs involved, and people have rights against whoever it may be that is actually the subject of the investigation. You have rights against whoever that is who caused you to get roped into that, and not many people know that.
So would you say? So, for instance, if you are being called in front of the SEC because of something that you did within the scope of your employment, are you essentially saying that you're entitled to reimbursement from your employer because of you're essentially acting as an agent of the employer?
Well, I first like to qualify that with a forward-looking statement.
Nice best practices there.
Yeah, right.
Some practical lawyering tips. There are in certain. It depends. There's certain indemnification statutes. Depending on the state, it's usually on the state level. In some situations, there's administrative guidance that suggests under federal law that you're entitled to reimbursement. That remains to be seen. I haven't seen that yet, but depending on what jurisdiction you're in, we're in California. We have multiple statutes that provide for indemnification rights. Typically, it needs to be in some sort of written agreement, but there's ways around that, in equity.
So if you were, I guess let me think about this. Like if you were an employee and your employer asked you to do something that you thought that potentially could be unlawful, what should you do?
First, I would consider this all the facts and circumstances. If you come to the conclusion that you believe what you're doing is wrong, I would refrain from doing that. Definitely don't break the law. That being said, if you do something that's in the scope of your employment that somehow involves you getting roped into one of these investigations, I would do a little bit of research to figure out what my rights are.
Can I give the correct answer, gentlemen? The answer is call Global Legal Law Firm.
Yeah, absolutely.
So to what extent, do any of these people have a duty to investigate, right? So I think, kind of, and a lot of this, is probably very like state specific, but if someone tells you to do something and you're not sure if it's a good idea, but you don't know, does that change your rights and obligations here at all?
It depends on the circumstance. Like, for example, if for whatever reason you're being investigated for you are the subject of the investigation under federal securities laws, depending on what statute, there's usually a scienter requirement. So if you had no knowledge of what really was going on, you didn't have the intent, you might be able to potentially have a defense to the claims that the SEC is making against you. In some situations, that might not be true. but yeah, they're
So is it so I guess the idea is it's not just actual knowledge, but there's a constructive knowledge component to this where they could say maybe you didn't know, but you should have known, or with reasonable investigation you would have discovered, and we're not going to let you get away with like willful ignorance in this situation. Is that kind of the design of the scienter requirement?
yeah, absolutely. Yeah, you can't just bury your head in the sand and just say, "Oh yeah, I didn't know." You have to actually, if you have facts that tip you off that something might be wrong, the commission or even a uh, private party who's suing you under like a private right of action under the federal securities laws, they might be able to point to, hey, like yeah, maybe he didn't know, but he had all this information, all these documents, like that showed that he, yeah,
He could have known if he just read the documents that were in his email box, right?
yeah.
Something like that. I mean, so how often do these situations arise in your experience? Do you see a lot of these come across your desk, or are these rarer as opposed to like a typical breach of action or breach of contract action? Right. So how cognizant should people be of the potential for this kind of action against them?
Yeah, it's relatively infrequent as compared to a run of the mill breach of contract action in the litigation context. Um, but that being said, it can always happen, especially if you're dealing with sophisticated business entities. And like you said, you don't even need to be the owner of a publicly traded company to be investigated. The securities laws also apply to private, LLCs, LLPs, like business entities. If you're accepting money from someone as an investment, like you're subject to the laws. So it's becoming more common in the payments industry for sure.
Yeah. So how does this interface with other administrative bodies? Because you mentioned the FTC, right? And I think because we do payments, there's a lot of stuff with involving the Bank Secrecy Act, right? So to what extent, could there potentially be uh, enforcement by the Federal Reserve because you didn't do AML or you didn't do KYC? Right. So are those processes different than something in a securities proceeding? Like how do these proceedings differ across administrative bodies?
So the procedure is relatively the same across administrative bodies. The substance is different though. Like if you're being investigated by the FTC, you're not dealing with federal securities laws. You're dealing with typically like the Sherman Antitrust Act or the FTC enforcement will be investigating potential violations of anti-competition laws.
Yeah.
So the substance will be different, but the Administrative Procedure Act still applies.
So the way you would attack a regulatory proceeding is pretty uniform across all the bodies because they're all governed by the same procedural body of law. Is that what you're saying? The Administrative Act?
Yeah, like well, all agencies have not all, but substantially all administrative agencies have an enabling statute, and the enabling statute gives them authority, and in most circumstances, outlines the procedure they need to follow, to issue rulemaking, engage in rulemaking, and perform, informal and formal adjudications.
So is attacking the enabling statute, something in your toolbox to actually fight one of these administrative actions?
Uh, yeah, and actually, I would say that you wouldn't. The best approach might not even be to attack. You could attack the statute on, a facial constitutional challenge, but I think a better approach in most circumstances, from what I've seen in our industry, is the best way to attack the agency decision is actually to look to that statute and formulate and articulate a reason to the judge why the decision they made is outside the scope of that regulatory authority in the enabling statute.
Fantastic. Is that similar to how essentially people attack decisions on the basis of unconstitutionality because these things are this is a document of grant, right? So it's so if unless there is authority specifically granted by the language of this document or this provision, they cannot otherwise regulate it. So I mean, so how do these federal administrative actions differ from something on the state level?
You mean like an administrative action from a state agency?
Yeah. So for instance, if it was like the California DFPI or something like that, would it be substantially different in terms of how you would contest that kind of action and the way that procedurally that gets evaluated?
Yeah, it's a procedurally different process, but at the same time, it's the same analytical process. There's a state. Most states have like a state enacted, based on the Federal Administrative Procedure Act. But that state will have their own, like for example, the California Administrative Procedure Act, and you would look to that statute when challenging a DFPI decision or rulemaking.
So you would say that the way you would approach a state administrative action would be similar. I mean, obviously the specifics are different because they're different bodies of law, but you'd still approach it the same way analytically.
Yeah.
I mean, and what's and I guess could you ever have a situation where you're being, brought before bodies on both the federal and state level, or is there kind of bar on that? So for instance, in securities, right? So could the SEC come after you and the California Securities Commission? Can they also come after you for the same thing?
Yeah, absolutely. Under state in California, our blue sky laws, you could get investigated by the SEC for violations of federal securities laws, and then by the state regulator for blue sky, like state securities law violations. So yeah. And you could even be on the federal level. They call it a parallel investigation, where you're being investigated by both the SEC and the Department of Justice. So you could potentially have
like 3 different agencies coming after you.
I wouldn't want to be in that position, but it's possible.
Well, it sounds like we need you if we're ever in that position, right, Bill?
Yeah, I absolutely know how to handle a situation like that.
So I mean, so in those specific situations, right? So what's the kind of what's the kind of behavior that would give rise to that kind of tri-party investigation?
That would involve some very egregious conduct. It would be extraordinary, but we're talking about extreme malice, just disregard and potentially criminal behavior.
So would there be any kind of preemption? Like, so if the DOJ wants to do something, would that supersede anything that would be done on the state level, or are all these things kind of hammering down on you concurrently?
In many cases, it could be concurrently. It really depends on what section of each statute the agency on each level is relying on. But in a lot of cases, if you're dealing with a state statute that is valid, facially valid, and it's not in conflict with a federal statute, yeah, you're getting investigated by both, and it can happen.
We want that case. Gentlemen, as we come to the end of this podcast, Jarvis Lagman, I'm going to give you the last word. Bill, is there something you'd like to leave our audience with when it comes to regulatory defense and how you, even in particular, can be of service?
Yeah, like I said before, it's just like and this goes with any body of law, any industry, just across the board. It's very important to understand your rights and obligations. Like, you have rights. Like, most people need to understand like what rights they have, and be willing to potentially have those rights enforced to prevent overreach, like not only by the government, but private actors.
Yeah, and just in conjunction with what Bill's saying, I think that, because there's so many different regulatory agencies and bodies of law that really could impact how you conduct your business and under what circumstances you could come under fire from, these different bodies of law. I truly recommend that, whenever you're making a business decision or employing a sales practice, as aggressive as you may want to be in doing that, you must always be truthful in what you do, right? Because I think at the core of all these laws, right, is this, is essentially a duty to be honest, right? So, so to the extent that you're engaging in any kind of practices where there's some kind of dishonesty or you're pushing the line of what honesty is, I would want to take a step back from that line, 10-foot step back from that line, because it's not worth it. Or you're going to have to call someone like Bill to bail you out.
Absolutely. Listen, gentlemen, thank you very much for your time today. And thank you for listening to the end of this episode of the Payments Experts Podcast. We've had today Senior Associate Attorney Jarvis Lagman, as well as Bill Petti, Associate Attorney at Global Legal Law Firm. Give us a call. Thank you for listening.
Thank you, Jeremy.
Thank you, Jeremy.
Thank you for listening to this episode of the Payments Experts Podcast. New episodes, first and third Thursdays. If you're interested in learning more about PEP and how Global Legal Law Firm may be able to assist you, please visit us at globallegallawfirm.com. To schedule a free consultation, give us a call at 888-846-8901 or email us at pep@attorneygl.com. And once again, thank you for listening.
1, 2, 3.